Margaretha Wewerinke-Singh is an Associate Professor of Sustainability Law at the University of Amsterdam, Law Faculty, and co-founder of the university's Climate Institute called SEVEN. She is also an Adjunct Professor of Law at the University of Fiji and a member of the Permanent Court of Arbitration in The Hague, Netherlands. Her work builds on 2 decades of research on human rights and social justice and involvement in international climate negotiations, as part of which she has advised governments and civil society and UN agencies across the globe. She co-led the legal team of Vanuatu in the climate advisory proceedings before the International Court of Justice, the ICJ, and the Inter-American Court of Human Rights, while also she currently serves on the Human Rights Committee of the Netherlands Advisory Council on International Affairs and advises the Office of the Prosecutor of the International Criminal Court. Elisa Morgera, welcome to the Netherlands, is a Professor of International Law and Sustainability at Durham University and Professor of International and European Union Environmental Law at the University of Eastern Finland. She was appointed as the United Nations Special Rapporteur on Climate Change and Human Rights in May 2024. Previously, Elisa worked with the UNFAO in Italy and the UNDP in Barbados and continued to collaborate with the United Nations and other international organizations. From 2019 to 2024, Professor Morgera directed the One Ocean Hub, a global research collaboration on human rights and the ocean. She has published extensively on human rights and the environment, the human right to science, as well as the human rights of small-scale fishers, indigenous peoples, and children related to the climate, biodiversity, and the ocean. We will now listen to each one of them for about 30 minutes before opening the room for questions. We start with Professor Wewerinke-Singh, who will speak on Beyond Loss and Damage, Climate Reparations in International Law. She will be followed by Professor Morgera, who will speak on reparations for climate harm, international human rights law, and transformative change perspectives. Both the talks will be recorded, but the subsequent question-answer session will not be. Therefore, please feel free to ask questions either online or by joining us in the mic over here in person. Once again, please join me in extending our warmest welcome to both the speakers. Now we can begin.
Well, thank you very much, Masumi, and thank you to the whole Repair team here for organizing this lecture series and for inviting Elisa and I to join you for today's lecture. So I thought that it might be useful if I briefly kind of sketch the field about how loss and damage is dealt with on the international law. A little bit of background also on the politics, and a bit of history about how certain concepts, terms, ways of addressing loss and damage have come about, and then some reflections on where we stand today, state of play in different spheres, particularly the climate negotiations and the UN General Assembly. And then hand over to Elisa for probably the more interesting part of the role of human rights in shaping how loss and damage is dealt with, and also a bit of a vision for the future, more forward-looking. So if you feel a sense of despair or frustration when I talk, then please wait for Elisa to take over, and then she will bring back the optimism, because what I am going to share is a little bit disheartening at points, because the pattern of addressing loss and damage under international law, and I'm talking, when I say loss and damage, I really mean specifically climate loss and damage. So the pattern is one that is characterized by avoidance on the part of essentially the states that bear most factual, moral, and indeed legal responsibility for causing loss and damage. Loss and damage there's no, as you will know, there's no agreed definition of loss and damage on the international law, but broadly speaking, it's understood to refer to adverse effects of climate change that have not been addressed or cannot be addressed through mitigation and adaptation. So that is harm from storms, like storms that are that have been made much worse by climate change, or sea level rise, things that cannot easily be repaired. And then specifically when we talk about things that really cannot be repaired anymore, that are lost, those are the losses, and then damages is usually where you can still fix things to some extent with money. Loss and damage is a term of art. It has entered the climate negotiations primarily to avoid using the term reparations. It wasn't meant to be a legal term. And if you trace its origins, they go as far back as the Rio negotiations, where the climate convention itself was negotiated, the one that was adopted in 1992, the Framework Convention. At those negotiations, under the negotiating committee, the AOSIS, the Alliance of Small Island States, had forth a proposal to address sea level rise based on the polluter pays principle. That proposal, it was formally submitted, but it was not, as you know, incorporated in the treaty. There's a trace of it in a reference to insurance. That's what was left of that proposal. And then for many years, it was essentially politically impossible to reintroduce the topic in the climate negotiations, so the negotiations under the climate convention, the conference of the parties and the other subsidiary bodies. And that changed again in Bali, 2007, where essentially the same group, but now a little bit broadened to broader group of developing countries, succeeded in inserting something referring, still quite vaguely, but referring to loss and damage in what was then the Bali Action Plan, the outcome document of that particular COP. And that didn't die out anymore. That stayed alive, that thread, and then it developed. So there was a continued push for developing some kind of architecture around that, and the biggest breakthrough was in Poland, in Warsaw, in 2013, when the Warsaw International Mechanism on Loss and Damage was established, and that still exists, and it has had several subgroups, task force. Most importantly, it has an executive committee where loss and damage is still mostly studied, discussed, not actually really very much addressed. Then another institutional breakthrough was at am I saying it correctly? Glasgow, where the states agreed on the establishment of the Loss and Damage Fund. And that fund exists now, but essentially it is an empty bucket where states can voluntarily put money in the fund, essentially, but there's no mechanism for apportioning responsibility for paying into the fund. There's certainly nothing like an obligation. And if you look at the relevant decisions and also the Paris Agreement, Article 8 of the Paris Agreement, which anchors loss and damage in a treaty. There's also significant development, of course, because prior to that, it wasn't anchored in a treaty. It was the kind of emerging regime was based on COP decisions. So now it's anchored in the Paris Agreement, but the language there is very soft and ambiguous, right? So when it comes to even obligations around finance, technology transfer, there the language is framed in terms of obligations. The verb that is used there is shall, and here for the loss and damage architecture, that is not the case. And so it has still been argued that there's no obligation to provide finance for loss and damage. And loss and damage also, unlike adaptation, for example, is not linked to the main financial mechanisms of the climate regime. And so there's no like concrete, easy channel for funding to be supplied for addressing loss and damage. So, and then I should mention also that all of these developments, every single decision that did something on loss and damage, because it's of course it is very incremental, right? It's every COP is again a small step forward, but all these small accomplishments were the result of huge battles on behalf of the most vulnerable states and enormous resistance on the part of the states that fear that they'll be held accountable. The frustration amongst climate vulnerable states about how loss and damage is being addressed, or rather actually being avoided, was one key factor in the decision ultimately to seek recourse outside of the climate regime. And that conversation started really in earnest after Paris 2015. So the Paris Agreement was adopted. It was at that point it was a remarkable achievement, because it was the best possible outcome that could be achieved politically at that point in time. But at the same time, it was very clearly a weak treaty without legally binding emission reduction commitments, without clear mechanisms to ensure that the goals that it set could be achieved, and indeed with provisional loss and damage that was remarkable for its presence, but at the same time was weakly formulated, as I said. And then also quite significant is that in the accompanying COP decision, the decision of the Conference of the Parties that adopted the Paris Agreement. So the Paris Agreement, the treaty was annexed to that particular decision CP 121. It contained a paragraph which stated that Article 8 of the Paris Agreement does not provide any basis for liability or compensation. Involve or provide, I think is the language. So with that, it was clear that liability and compensation were excluded from the scope of Article 8 until the point that the COP would adopt a decision overturning that, which was unlikely to happen at any point in the foreseeable future. So it was in the Pacific that this discussion about what else to do, what can be done besides the climate regime, really started again in earnest. It's a discussion that has always been there, even prior to the adoption of the convention in 1992. There was a discussion about state responsibility and how general international law could be brought to bear to climate change and also injury and harms. But it was, I think, the disillusionment of Paris that really provided an impulse again to that discussion. That plus also worsening climate impact. So 2015 was not only the year of the Paris Agreement adoption, but also the year that Category 5 Cyclone Pam hit Vanuatu and several other Pacific Island countries, causing tremendous losses and damages amounting to more than 67% of Vanuatu's GDP for that year, and also real non-economic losses and damages. So we saw at one gathering with participants from Tuvalu, we saw their graveyards where the ancestors are buried, being flooded, and essentially remains there, being swept away by the sea, and this land becoming inhabitable that had been the sacred traditional land for many generations. And so these kinds of losses are impossible to quantify, but very real and again present. So it was a group of students at the University of the South Pacific, the MLS campus of USP's law school in Vanuatu, who came up with the idea to bring climate change before the world's highest court, so the world's biggest problem before the world's highest court. They convinced the government of Vanuatu to start a diplomatic campaign at the UNGA towards a resolution that would request an advisory opinion from the International Court of Justice to clarify the applicable law on climate change, and then with a focus on state responsibility. So this culminated in resolution 77-276, adopted on the 29th of March 2023, so 3 years ago, by consensus. It was a different geopolitical situation at that point in time where that was possible. And that resolution put two questions to the court. The first asked about the obligations of states to protect the climate system and other parts of the environment for present and future generations, and against climate harm. I'm paraphrasing. And the second question is about the legal consequences of essentially breaching those obligations, and the legal consequences vis-a-vis states, first sub-question, and the second sub-question, peoples and individuals of present and future generations. And I'm sure Elisa will speak to that, because that is very much the human rights dimension of the question, as it's most relevant to loss and damage, because that's where we speak about violations of rights. And so the phrasing of the question was very deliberately chosen and negotiated. And well, I could speak a lot about the political process around that precise formulation. But when you look at that resolution, the text, what matters most for the purpose of loss and damage is the phrasing "have caused" in question B, because that is where the court is asked to also look at the past and to reckon with conduct over time, and not just address what states are supposed to do now with an eye to the future. And that was, of course, very contentious and very tough negotiation, but that phrasing was retained. And so when you look at the opinion itself, the opinion, you see, the opinion is remarkable for its the ground that it covers, the depth. A whole range of obligations are identified. So very critical is that the court made it clear that these obligations are not just contained in the climate treaties, but they cover essentially the entire spectrum of international laws, as other environmental treaties, and customary international law. Most importantly, the court identified or essentially clarified that the customary obligation of prevention of significant harm applied also to climate change, to harm to the climate system. So the climate system is part of the environment, and states have stringent due diligence obligations to prevent significant harm. And then the court identified a customary duty of cooperation as well. And then what do states exactly need to do to cooperate to fulfill that obligation? well, the court said at the very least they should participate in discussions to meet, amongst other things, the Paris Agreement goal, and then the straightforward way for states to do that essentially is to participate in these treaty regimes, comply with the treaty obligations. If they choose to not do that, then the burden is on states to prove that they comply with this obligation of cooperation. And that's a very significant move, of course, because when you have states like at this point the United States that decides to pull out of these treaties, it means that it doesn't absolve these states of their obligations. Quite the opposite, actually. It makes it then puts the burden on the state to show that they comply with these customary obligations that continue to apply to them. And then on state responsibility, the court's findings are very significant in that the court confirms that the law of state responsibility applies to any conduct of states that causes significant harm to the climate system. So here the court also affirms that even if states exclude certain parts of conduct from the climate regime, or they choose to report in particular ways, that doesn't affect the substance of their obligations. So, for example, military missions, shipping, aviation, there had been an impression, probably among some states or other actors, that those sectors would be excluded from international law, because they're not reported, not included in the regimes. But the court brings it back to basics, essentially. What matters is this causality of causing harm, and so the full spectrum of activities that cause such harm, activities as well as omissions, of course, is covered. And that includes production as well. And it's also very significant because fossil fuels, even though being the main driver of the climate crisis, have never been explicitly or meaningfully addressed in the climate regime. It's all about territorial emissions, essentially. So where do we stand now then? We have this landmark opinion now from the ICJ, which sets out the law as it applies to all states, makes it clear that causing harm could amount to breach of obligation, triggers state responsibility, and then the general consequences of state responsibility apply, which are ceasing the wrongful act, where appropriate, offer guarantees of non-repetition. So that could be adopting legislation, for example, to avoid slipping back into the conduct that caused the breach. And then also reparations, including restitution as a preferred form of reparation, and where that is impossible, compensation and or satisfaction, so more symbolic means of redress. What is particularly, I think, satisfying for those who follow these very difficult negotiations in the climate regime on loss and damage, and then heard the biggest kind of opponent of progress on loss and damage in that regime argue before the ICJ that, well, loss and damage, the court should not make any pronouncements around state responsibility because states had already agreed to deal with such matters under the climate regime. But also at the same time, the court should look carefully at decision CP 121 because it excluded liability and compensation. So the court should not say that it was actually materially dealt with there. It's a different. There are no obligations to do anything about loss and damage, but it is a topic that is covered, and the court shouldn't. Essentially, it's a lex specialis argument. It's lex specialis, and so it is excluded from the general law state responsibility. The court didn't buy that. It's like you can't have your cake and eat it. The court notes it's addressed there, but actually, because it is not dealt with in a way that leads to the exclusion formally of the law state responsibility, and instead of signals that states never intended to exclude the law state responsibility from applying, it falls on the state responsibility. And then the court even uses the terms loss and damage to clarify that the law state responsibility applies to loss and damage and injury. So the court treats it as almost one and the same thing. So when we talk about loss and damage, we are talking about what amounts to injury under the law state responsibility. And injury is a very hard legal term with a clear meaning. Injury, that is the thing that must be repaired. And the obligation under the general well-established law of state responsibility on reparations is that the reparations must be full. So a state that causes injury must repair that harm, that injury in full. And an injured state has a right to invoke the responsibility of the state that has caused the harm. And then also significant is the court said that these obligations are erga omnes obligations, so they are not owed in a kind of contractual way between states per se, but they are obligations that are owed to the international community as a whole, because what is at stake is of common concern, is common interest. And it also means that any state, even a non-injured state or a state that can prove that it's injured, can invoke the responsibility of a responsible state. And then it can, of course, not claim reparations for harm if there's no injury suffered by that state. But there can be injured parties or beneficiaries of rights that are injured, those who suffer human rights violations as a result of climate change. And then a state that invokes the responsibility of a state that's causing the harm can demand that harm suffered by others is repaired. That suggestion that would be part of the obligations to be complied with. Again, very significant pronouncements. One caveat is that the court, of course, did not pronounce on the responsibility of any particular state because it did not apply the law to the conduct of states. That is an exercise that would need to be carried out on a case-by-case basis in light of a whole set of facts. And of course, that would require quite a sophisticated, comprehensive analysis, because one would need to look at states' conduct over time in light of obligations that were applicable at those points in time, and these obligations evolve with knowledge of the science of climate change as a phenomenon, of the harm that it would cause, the foreseeability of that harm at particular points in time. So that's not something that the court could do, of course, for every single member state of the United Nations, even if it would have wanted to do that. But that's also not what the court is supposed to do in an advisory proceeding like this. But of course, that option is always there, including through a contentious case, litigation. But of course, the preferred route to addressing loss and damage remains the multilateral route. And so the small island states that requested or that campaigned for the request led the whole initiative, essentially, including Vanuatu, have tried to bring the opinion back into the climate negotiation process at Belém last year, but unfortunately it was politically impossible to include even a reference to the opinion in the outcome documents. That was a red line for many states. Saudi Arabia, amongst others, essentially the main historical and current polluters are very wary of giving the opinion any oxygen. Currently, as we speak, a very difficult negotiation process is underway in the UN General Assembly to adopt the follow-up resolution. So when it's common practice in the UN General Assembly when the General Assembly has requested an advisory opinion and the court has delivered it, to receive that and acknowledge it, welcome it, and then to articulate some follow-up points. That is also proving to be extremely difficult. Vanuatu's Foreign Minister Ralph Regenvanu has in the media spoken about essentially harassment by the United States, which is seeking withdrawal of the resolution draft, and that's unlikely to happen. But the negotiations are difficult. Also Elisa and her colleague Astrid Prentice, and I think a few others. Yes. The special rapporteurs have issued a statement also encouraging states to support this resolution because it's very important follow-up and just a matter of general UN practice that needs to be respected, especially in case of such an important resolution. But that is a space to be watched as well. And of course, that the more that can be done through the multilateral process, the better. And the more disappointing the results there, the more likely also that other paths will need to be walked in order to get some progress. That ultimately, because ultimately what this is about is some tangible redress for victims, and we have still not really seen any of it despite everything that I just talked about. So here is where we need Elisa to take over with an optimistic vision for the future.
Yeah, well, thank you so much also from my side to the whole Repair team for the invitation and the honor to be sharing this space with Margaretha. I'd also would like to start, I think, with honoring her thought leadership in this area of international law, all her, I guess, life work that has contributed so significantly to bring all of us to this juncture, legally and politically and in terms of international cooperation. So yes, it is a great honor, and I've learned a lot from your work, and I've also personally been very inspired in hearing the arguments based on your scholarship in the different hearings processes, including at the Inter-American Court. I think very thorough understanding of the opportunities that international law already provides to really give that concrete, real, holistic remedies to climate harm. And I think all the support that you provided to Vanuatu for their leadership, the Pacific students, all of that needs to be honored and recognized at the outset. It's also really important to start from your also perceptions of this whole situation is about denial at many levels by states, but also by the economic actors who are the main responsible for climate change and who have known for decades that this was the case and have decided not only not to share this science with public authorities and the public, but they have over decades elaborated more and more sophisticated ways to keep us all away from that truth, to keep us all away from meaningful action to prevent climate change from getting to the global crisis we're facing. And they've done so to a point where now we're seeing the latest chapter of this playbook of climate disinformation and obstruction being the destruction of our democratic structures, the destruction of the United Nations and multilateralism, and in fact, repeated acts of illegal armed aggression. This is what we're facing. And while we have a moment of unique legal clarity about the state obligations to prevent further climate harm, as well as to remedy of existing and ongoing and compounding climate harm, the denial continues to exist. And in fact, some of the most disappointing reactions have been reactions to the ICJ advisory opinion, saying that it does not really change the position of many dominating states in the negotiations were very much the ones that before the ICJ argued for those very narrow interpretations of international law, the lex specialis argument, and generally saying that in so carefully crafting international climate law, they have effectively isolated it from general rules of state responsibility. The court could not have been clearer that that approach is not legally accurate. And yet that approach has framed, again, decades of international climate law and climate cooperation. So we are at a stage in a paradox where on the one hand, the ICJ has effectively refuted every single legal argument that the countries most responsible for climate change have made before it, and they keep making in the context of the international climate regime. But at the same time, we are also facing a situation of continued denial, legally and practically, including at the stage of looking at this advisory opinion at the UN General Assembly in a cooperative way rather than in an adversarial way, choosing multilateral ways to ensure that the benefits of climate reparations are also shared equally. Because I think the key point that is somehow hidden in all this denial is that we are all to stand to benefit. And in fact, we urgently need those climate reparations for the protection of everyone's human rights right here and right now from the multiple levels of climate harm we're facing. And while it's such a bitter paradox, I was thinking about, the Paris Agreement 2015 and then Palm cyclone happening in the South Pacific. When I had the honor to visit Vanuatu as my first country visit, that was actually happening at the same time at the oral hearings at the ICJ. And I was hearing testimonies throughout the day about how 2015 has been the year where everything changed in Vanuatu and many other Pacific countries, whether what seemed an unprecedented destruction became a yearly reality. The children that were born from 2015 to today have never lived a secure life, are fearing every year cyclone season, and even the year before have faced 3 category 4 and 5 cyclones, 2 in the same week. I mean, this is just unconscionable and unconceivable conditions of life. And I think what's happened since then is that for how much maybe some countries thought that they were safe from climate change, this is clearly not true anymore for any state that I can think of. But of course, there is a huge difference between the countries who have been bearing the brunt of climate change for over a decade. These are the countries who are facing compounding impacts day in, day out, in situations where, again, it's almost impossible to imagine how you can reconstruct and protect where the impacts are so compounding. And I think honoring that experience as opposed to avoiding even listening to it, understanding that what we've learned through that pain and loss in those countries is essential, again, for all of us to see what is meaningful reparation that can protect all of us in the context of climate change. So what I'll be discussing with you is kind of thinking about law and where we are at with legal clarity, going through the human right to effective remedy and state responsibility under international law, from a sense also of the evidence, both the scientific evidence, but also the lived experiences of the human rights holders most affected by climate change. And through that lens, understand fully the potential for transformation to the benefit of everyone of climate reparations. And that's really to try and engage in this conversation, which, yes, is very legal, but really is a matter of, I think, public consciousness and understanding that while politically the advisory opinion and the discussion on climate reparations, again, may be portrayed in very adversarial tones, and I think be misrepresented as an attack and an erosion of democracy and public budgets to the benefit of distant countries must be understood as in terms of solidarity, in terms of the most effective measure that all states and all public budgets should be considering for addressing a crisis that is truly global and it is affecting everyone right here and right now. So in that sense, what I like to say is to, first of all, actually quote one of my favorite quotes from another UN Special Rapporteur on the right to health, who talked about the reparations, including in the context of climate change, as about restoring human connections with nature, facilitating individual and community healing, and building intergenerational alliances. This is what climate reparations are about. And I think it's interesting that it comes from the perspective of the human right to health. And what I've tried to do in my own work is really bring in not only climate science, which has been very clear about the fact that among all the reparations we need, action across different levels, which I'll now discuss about fossil fuels, is the #1 priority, but also looking at health science and how the medical community across the world has been mobilizing to say fossil fuels and the fossil fuel-based economy, not only within the energy sector, but across, is health harming, is deeply health harming. And even if we were to set aside climate change, which is also health harming, fossil fuels in and of themselves are harming children, women. In fact, all of us, our bodies are filled with fossil fuels, with plastics, with air pollution, in ways that are unacceptable. And again, there are harm here and now for everyone, but particularly the most vulnerable people in our societies. And so lack of action on climate change and on fossil fuels is inherently a form of discrimination and has been recognized, for instance, by the UN Committee on the Rights of the Child as a form of structural violence. But what's important is, again, it's not just the pain that comes from this realization, is also the hope that we have, that this makes sense for the climate, this makes sense for our health, and that how can we not want meaningful action that is about healing for all of us? And so on that basis, I think what's really interesting is that we need to think about climate reparations and the legal clarity arising from the ICJ advisory opinion in terms of multiple areas of scientific evidence that show that it is about protecting the climate system in a much more holistic way that is being done within international climate law. So moving beyond the carbon tunnel vision, which again has helped hiding fossil fuels in plain sight, in plastics, in petrochemicals, in military operations, and really thinking about prioritizing action nationally and internationally that is the most healthy for us and for the planet. And we know what the action is. We know it from climate science, we know from planetary health science, we know from other medical science. And again, we know it from the lived experiences of those who are most affected by climate change and who, through their experiences, understand the systemic change we need. And this is why it's so important that from an international human rights law perspective, looking at climate remedies means that those remedies need to be co-developed with the most effective climate holders, most affected human rights holders by climate change. And this is important because if you think about who has the power and the obligations to provide those climate remedies, those are the countries who have contributed the most to climate change. And in a way, their worldview is the one who is least likely to provide meaningful reparations. They respond to the needs of those most affected, but also bring that transformation of our economic systems and all our systems that have so far supported further expansion of fossil fuels and more climate harm. So again, it's about really thinking about how we engage in a conversation that's about learning and recognizing that the lived experiences of those most affected states and people are the ones that have actually the best insights about the most effective remedies, which again will have benefits for all of us. And this has been clarified in the Inter-American Court of Human Rights, is essentially about co-developing, reimagining, reconstructing healthier economic models, the move away from fossil fuels as the main cause of climate change, and move us into looking at what are existing healthier economic models that are themselves being crushed by fossil fuels and all the large-scale businesses who are very much embedded and continue to make more and more profit, control more and more land, have more and more market power, and create more and more harm to our health and to the planet as part of that economic model. So let's go now through the different forms of remedies that have been clarified by the court. Each and every one of them provides the opportunity for transformation. And this is why it's interesting to think about how we convey and how we all pilot in academia, working with social movements, with cities, with any parts of states who are very conflicted within governments, with putting those remedies into practice. And let's see what happens. Let's see how we can find and understand how this is beneficial and essential for all of us. So of course, satisfaction, to me, that is about truth telling and learning to listen to the truth. So the opposite of the denial practices that we've seen, unfortunately, day in, day out, at the General Assembly, at the Climate COP. Unfortunately, we've even seen them at the Human Rights Council and in the plastics negotiations, these really brutal forces of oppression, even within diplomatic processes, that really do not want to even mention the word fossil fuels, they do not want to mention the ICJ advisory opinion, who are really trying to embed these dynamics of denial in all our multilateral processes. And rather think about how we need to make those multilateral processes as inclusive as possible and really center the voices of those most affected by climate change as a process of listening to truth and understanding then how we make that understanding helpful to unlock other meaningful remedies. And in a way, we know that there are actually beautiful methodologies to do so. We have done some little experimentations with art-based approaches, with children-based methodologies, which are based on fun and play, which seem like almost shocking words to say in diplomacy. And yet that is what we need to be able to trigger all our cognitive capacities, including our empathy, including our imagination, to be able to overcome that practice of denial that has surrounded us, and also the decades of disinformation that have shaped in many ways our understanding, our initial instincts when we think about what we need to change in our economies and what really is at stake there. The second is rehabilitation. I think this is crucial. I'm originally an international biodiversity lawyer, and I find that again, that distinction between climate and biodiversity has been a really problematic one, both because it misunderstands how our life supporting systems work, but also because, again, it helps to isolate climate action from truly understanding root causes and impacts, including impacts on human health and well-being that have been marginalized in international climate law, national climate laws and practices, and have led time and again to human rights violations, both because of climate inaction and, most painfully of all, also because of certain forms of climate action, which still continues to support in different ways reliance on fossil fuels. So rehabilitation, and particularly the emphasis on ecological restoration across all the three advisory opinions, is a crucial area where I think we can see transformation, where we can start really supporting planning and budgeting at the nexus of climate, biodiversity, water, food, and health. We have best available science available to us, produced by IPBS, the Intergovernmental Science Policy Panel on Biodiversity and Ecosystem Services. We have the work of the Special Rapporteur on the right to water and the right to food and the right to health, all pointing in the same direction. And what is, again, paradoxical here is that ecosystem restoration is a primary obligation. It's a treaty obligation under the Convention on Biological Diversity. It's an obligation under the law of the sea. And now it's also been recognized as a secondary obligation under customary law and under multiple treaties, including climate and human rights treaties, to remedy to climate harm. To that quote from my colleague, the Special Rapporteur on Right to Health, ecological restoration is where we can understand the opportunities, first to live in nature, to rebound, and to do so in ways that we as humans might not even fully comprehend and plan, but that will be so beneficial for physical and mental health, for present and future generations. But it can also reclaim a space for all of us to think about our self-determination. If we create that space for moving away from fossil fuels, I think to me that comes from ecological restoration. And we're seeing some really incredible, joyful practices, even in Cancer Alley in the US, where community-led ecological restoration has created a space for communities themselves to interrogate the harm that they've suffered intergenerationally, for deciding about their own future, what it should look like, and through that really have a very holistic vision of protection of human rights for themselves, but really for benefits for many others, locally and globally. The other, I think, crucial form of reparation is guarantees of non-repetition. That, to me, again, it's at the same time a confirmation of our primary obligations, which, again, the ICJ has made clear, of phasing out fossil fuels, and as a secondary obligation to guarantee non-repetition of the cause of climate harm in the first place. In my own work as Special Rapporteur, I have already argued that even only on the basis of human rights law, states have an obligation to phase out fossil fuels, in fact, to defossilize across our economies. And of course, the analysis of the ICJ is broader across all areas of international law. And very much aligned with what my reports was finding, really looking at not only fossil fuel burning, but in fact, fossil fuel expansion, production, consumption, and subsidies. These are all ways in which states are violating international law, and these are all directions for how we ensure guarantees of non-repetition. I mean, crucially, again, thinking about like what this means in terms of protection of human rights, the medical community is very clear. Phasing out fossil fuel can be the one most impactful health intervention we can possibly make. But I think more and more we're also seeing in the last few months, unfortunately, how that is the only direction for protecting peace and for protecting our democracies. Again, so really thinking beyond that technical carbon tunnel vision about what's really at stake here and the length at which the fossil fuel-based economy and the actors within the economy are willing to go to preserve themselves at the expenses of human survival and planetary well-being. And then there's the crucial point of compensation. Very difficult. I think this might be the biggest red line of all the red lines. And I think that the opportunity for transformation there is engaging with parliaments and governments about human rights budgeting, engaging with taxpayers, and really discuss, is this where your tax money should be going? Should your tax go into the most lucrative business sector that has ever appeared on this planet, the same economic actors who are benefiting from multiple layers of public financing, who are benefiting from undue protection under international investment law, and who are placing all their externalities, once again, in our own pockets, to a point where, paradoxically, even with all the subsidies that are still going to consumption of fossil fuels, our living costs are going up everywhere in the world. We are facing now what other colleagues in other regions have been facing. Now it's becoming clear even here in Europe and other advanced economies who, again, thought they were shielded from the fact that climate harm is deeply rooted in economic inequality, and that the fossil fuel-based economy is an economy of sacrifice. It's an economy of widening that economic equity gap. And that is part of the DNA of it. And it's becoming so clear now. And so there's many forms in which that compensation can be made, taking into account historical responsibilities, current contributions, and respective capabilities. And it's really about, again, it's not just taking money away from fossil fuels, and in fact, requiring those companies who are clearly responsible and more also, and where we have more and more attribution science to really point out and who they are and what they have, what harm they have contributed to and in what proportions, to pay for that harm that they have caused, but crucially to think about where is that money going in terms of protecting our human rights and redirecting our economies towards the economic actors who are working towards a healthier, keeping a healthier life supporting systems and supporting our human well-being. And I think that's really where that aspect of compensation is crucial. It is an essential element of shifting the economic models. So I'm not sure how I'm doing with time. Maybe I'll try and wrap up in the next, in the next 5 minutes. And really thinking about how these are, I think legally, there has been no doubt that this is what needs to happen. How we go about it, I think, is very crucial because of those dynamics of denial, and also the fact that the fossil fuel industry has been ahead of us so many steps for decades. And we are both contending with their newest forms of denial and the legacy of those decades of disinformation, and really shaping our mindset, our imaginations about what a secure life, a modern life, a convenient life is about, and whether it really depends on fossil fuels, including as plastics, including as fertilizers and pesticides, which are the area where fossil fuels are still expanding, notwithstanding the fact that we are making such meaningful progress in decarbonizing our energy systems. And so to me, the legal conversations needs to happen in the context of very like a wide engagement with different bodies of science, planetary health, the political economy of the fossil fuel-based economy, and social sciences who help us navigate those tactics of disinformation and obstruction, and help us think ahead about how we frame this conversation, how we support conversation in very entrenched, across very entrenched views, and how we, and I think all the sciences, well, let's say transdisciplinary sciences around transformation, around solidarity, around connecting knowledge systems and social movements, for all of us to be much more aligned about supporting local, national, and international action to really comply with those obligations that the ICJ and the other international tribunals have clarified, including by learning on what somehow the amazing climate justice struggle has not achieved yet, where we're seeing a pushback even after incredible wins in climate litigation. We really need to understand what happens after that litigation, and how we can all support at all levels a meaningful conversation around all the ways in which denial is working towards obscuring the diffuse benefits of meaningful climate reparations. And I think one point maybe that I've become very interested is also how we engage with climate science, and particularly tipping point science, not because of the scary findings that are coming out from that science, although it's important to keep them in mind, but because of how it shows that all our destinies are interconnected. the protection of every person's human rights is interconnected with the protection of the human rights of children, of women, of indigenous peoples, of the peoples in the small island states and in the countries who have been most affected by climate change. Because whether we like it or not, what happens in the Amazon, what happens with coral reefs, what happens with the Atlantic meridian overturning circulation collapse, with the collapse of the current in the Atlantic, can change our lives from one day to the next. It's already changing our lives. And we can't just think that we'll be safe in our own country if we think that so far we've been privileged enough not to feel the brunt of climate change, because this is simply not how life on this planet works. And we have all the science, we have the commitment from scientists across the board to work together. And I think my source of hope is that we're seeing really strong reactions. We're seeing now a proposal from, for instance, the Netherlands and Colombia to lead a different multilateral space, the Santa Marta International Conference on transitioning away from fossil fuels. This is not going to be a silver bullet. There's still so many contradictions, even in the states who are showing international leadership and will be there. And yet every step in the right direction matters. Every opportunity to do multilateralism differently, more inclusively, more creatively matters. And we have to think that transformative change never comes from the top down. It always comes from the bottom up. It comes from all directions. We can never predict what will be the point where things change. And so it's important for all of us to be working as an ecosystem, to support states, to provide them with these connected areas of sciences and lived experiences, but also as academics to work very closely with diverse social movements, the children's rights movement, the indigenous movements, the land protection movements, the debt and tax justice movements, because we're all actually supporting the same agenda. But we need to be very clear about what that shared agenda is and be as joyful and creative in pursuing it wherever we can. Thank you.